standard essential patents at the ITC, and specifically Section 337 litigation. Joining us today, I'll introduce the panel again from your left to right, is Josh Hartman, who he is a partner at Merchant & Gould, and he's an experienced litigator with the Merchant & Gould's DC area office, and he's the head of the firm's ITC Section 337 group, and he also litigates IP and unfair competition disputes in district courts as well. So thank you for being here.
Thanks, Gene.
Josh. Next to him, we have Evan Langdon, and Evan is a partner and chair of the International Trade Commission litigation practice at Fabricant, and he has experience as a first chair trial attorney who focuses his practice primarily on Section 337 investigations before the ITC, but he also does intellectual property litigation in the district courts and appeals at the federal circuit as well. And last but certainly not least is the Honorable Theodore Essex, and Judge Essex served on the U.S. ITC for a decade, and now he is senior counsel at Hogan and Lovells in Washington, D.C. He's also the only person that I know that is both admitted to practice in the United States and admitted to practice in the United Kingdom as well. So always appreciate you being here, Your Honor. And what I'll do is I'll give you the first word on the panel to get us going with respect to the topic of SEPs at the ITC. I know you have a lot to say on the topic, but what is your preliminary thought?
Well, my preliminary thought is so much that it's gone around the ITC has been political more than actual legal argument, and that the idea that since we only provide injunctive relief, that anytime there's a, quote, standard essential patent involved, we shouldn't be allowed to get involved because by providing injunctive relief, and that's more than just allowing monetary relief, and so they've done that. However, and I'll talk to my colleagues here, that there has never been a case that I'm personally aware of where the parties actually presented evidence in front of ALJ on those issues, so that it's been mainly political outside of the hearing rooms. I wanted to throw something out. My friend Randy Rader suggested last time that I looked up quickly some of the Apple statements that have been in front of the ITC. And it says, Apple has stated, and this is their statement, not me projecting Apple, said, they'll refuse a FRAN rate with that until infringement was adjudicated and if it lost. And in a briefing, they said if it's adjudicated up through and including the Supreme Court, the U.S. Supreme Court, and they lost, then they are still entitled to a FRAN rate. So they will not take a license no matter what until they've lost at Supreme Court, and then they want a FRAN rate. And the question I put to Randy Rader, who wasn't able to answer it, and neither was I, and that is, if that is a willing licensee, because it says willing licensees get the FRAN rate, right? If that's a willing licensee, what the hell would be an unwilling licensee? Because they'd have to be worse than that, wouldn't they? So that's the first thing I want to say. The ITC has dealt with patents that purportedly could be standard essential. And I want to say things actually accurately because I find it amusing. And that is, there's no patent that is a standard essential patent that has been proven so until after litigation of some kind. You report your patent to the SSO that it might read on a standard. But until it's litigated, no one knows. So we've had a number of purported potential standard essential patents at the ITC. We haven't ever had one except in Samsung Apple where both sides agreed it was. The rest of them all been just purportedly. And no party I'm aware of put in evidence regarding the standard essential nature of the patent. And we may discuss that. That may be a good jumping off point for you to wonder, why is that and how would it help, if it would help at all. So that would be my opening.
Okay, great. Thank you. Evan, how about you next?
I don't want to jump to the end of the discussion, but there's a lot of discussion around whether or not injunctive relief is appropriate in standard essential patents, and as the judge here astutely noted, Apple is one of those, right? That if they're willing to say, I'm not going to take a license unless adjudicated through the Supreme Court, that screams that you need that injunctive relief, that you need the opportunity to bring them to a situation where that decision can come much sooner than all the way to the Supreme Court. And in front of last year, in front of Gilstrap in the Ericsson Apple case, he even commented in one of his orders that if the rate is determined, right, FRAND rate is determined, Apple still has multiple decisions. They can choose to take that and sign a license and go about its business. They can choose not to take the license and not implement the technology, or they can choose to not take the license and implement the technology anyway and adjudicate for patent infringement. So without the threat, in that case, like was noted, if that's not an unwilling licensee, if that's a willing licensee, then I think many of us up here would agree that injunctive relief is absolutely appropriate in these circumstances.
Yeah, and just for the record, this is why I refer to Apple as hell no. I mean, because their position in the ITC has been exactly that. What I say it is we're not going to take a license until we lose every time all the way up to the Supreme Court, and I interpret that as being hell no, we're not going to take a license, and people sometimes don't like how I characterize it, but I'm actually pretty accurately, not literally quoting them, but pretty accurately quoting what they've said, and it's frustrating. And I can only imagine what it is like for an innovator having to deal with that. But the ITC provides a great remedy. We'll talk about that in a minute here. But Josh, your preliminary thoughts before we dive off on too many tangents.
Sure. So just to pick up on a couple things that Judge Essex and Evan have mentioned, I think Apple does loom large in discussions about SEPs at the ITC, and that they're sort of ground zero in a way. Going back 10 years with the litigation against Samsung, the only instance in which the ITC has issued an exclusion order based on, again, standard essential patents or even allegedly standard essential patents.
Well, in this case, both
that one they
parties
actually
said
agreed.
it was.
That's what
they
I'm saying.
agreed.
Right,
so.
right.
That's exactly what I'm saying. That decision did not stand. USTR vetoed the ITC's order, one of the only times in history that USTR has done so for an ITC exclusion order. And I think this dovetails with something that you were saying, Judge Essex, about political considerations. Mm-hmm. It also reminds me of something that Commissioner Keefe was saying yesterday, comparing the FTC to the ITC and the way the different agencies handle this issue. I think for the most part, if you go back 10 years from the 794 investigation and you look at the cases since then and the way the ITC has handled them, they have been mostly non-political in their analysis of the issues. There has been real litigation on issues like the essentiality of the patent to the standard. There's been litigation on whether the parties engaged in FRAND negotiations. There's been litigation, including a recent decision on the promptness with which the patent owner declared its patents to the standard setting organization. And there's case law that's developed which provides, I think, some guidance to the industry about how to deal with these situations. In many ways, I think what's happened is that the ITC has effectively become the expert forum for litigating SEP issues in the U.S.
Yes, I think that it probably has. But Judge, let me go back to you. You have told me a number of times that there have been clearly SEP cases at the ITC, or it seems that they're clearly there, but that the parties don't seem to be all that willing to characterize them as such or ask for a finding of essentiality. Or what are your thoughts there, and can you elaborate?
Well, I'll be interested to listen to my colleagues that litigate as to their decision-making process. But there have been about, let's leave Apple aside, there have been about a dozen cases involving patents that could have read upon a standard. Let me phrase it accurately that way. As it turns out, in those cases that I'm familiar with, and going behind the screen without revealing any of the confidential business information, it appears that the decisions were taken by both the complainant and the respondents to not introduce evidence regarding the standard and essential nature of the patents. Now, I think personally complainants would not want to do so because, one, it wouldn't increase their case whatsoever if they proved they not only had a patent but a standard essential. And that would then risk their entitlement to injunctive relief, because the obvious response would be then you agreed to take money so you don't have to have an injunction and so forth. So complainants have never done it. Respondents have never done it either. And the reason for that is that in these cases, as it says about a dozen, you may know some new ones, I haven't followed so much, but about a dozen of these cases, respondents have done remarkably well in either finding the patent was invalid or finding it was infringed but didn't read on the standard. As a matter of fact, none of the complainants on these cases, as far as I can recall, the ones I've read, won. So the issue, although there are patents that certainly could be standard essential if evidence was reduced, the issue doesn't come up because complainants is not going to tell you their patent standard essential because they don't want to jeopardize their entitlement to relief. And respondents want to attack the patent. They want to attack whether the patent is actually standard essential, because it can be a valid patent and still not read on the standard. So they don't have anything to do with that either. So as it turns out, the ITC really has never had a case where that standard essential nature of a asserted patent was disputed. And I think the reason, and perhaps you can elaborate on why the parties wouldn't want to go there. I think I know why the complainants don't, but perhaps respondents have other reasons as well.
Evan, go ahead.
Right. I guess what I was going to, instead of answering that question directly, I'm going to kind of hedge around it a little bit here. But I think, well, because I think they going back to the 794 case, there was direction that was given out by the trade representative, USTR. That is, if you're going to an SCP case to the ITC, you have to develop a record on the public interest. There's public interest factors that have to be evaluated before an exclusion order can issue. And the reason that case was overturned there was not because it was a standard essential patent, it's because there was no underlying record of what FRAND negotiations took place. And so there's no way for them to evaluate whether or not that FRAND discussions, whether they took place or not, and whether or not someone met some of their FRAND obligations had any effect on the public interest. There just wasn't a record. So since that time, litigants have been careful about whether or not they're going to argue it's standard essential. But in the background and in the alternative, they do have to litigate for public interest reasons if they eventually want an exclusion order that they met their FRAND obligation if this patent is determined at some point in time to be standard essential. So they are developing a factual record. And since that time, it's 10 years now, right? It was 2000.
10 years.
10 years now. There has not been a case where the ITC has refused to issue an exclusion order. There's been at least 2 judges where was finding a violation and recommended an exclusion order. So in that time frame, either there was a settlement, finding a violation, which led to a settlement before an exclusion order issued, or the patent was found invalid or not infringed. So we haven't experienced in the last decade any refusal to issue an exclusion order, and that has led to an increase of filings of what you can call, for this discussion, we can call them SEPs, we can call them close to SEPs, unadjudicated SEPs, but there has been an increase in filings because the settlement rate is as high, if not higher, than non-SEP cases. So for the litigants, the way the market is bearing out, they are treating it as if exclusionary relief is on the table. And respondents sure are scared of that because you see these cases that once it goes to a violation, they're found to infringe. These cases are all settling. They're not waiting to see what is the commission going to do with it. They're not waiting to see how the public interest weighs out. They're not waiting to see if they're going to get bailed out by USTR because I think people have realized that was a very unique situation and it's not likely to repeat itself.
Let me jump in just a second. I'm sorry. But in the meantime, in this 10 years in that, we've also seen that I think it was Justice and the PTO have changed their recommendation letter, and they now have said that injunction relief exclusion orders are on the table, that there's nothing in the Fran regime and all the SSOs that would preclude that. So that from the time I started taking these cases up to now, this pendulum seems to have swung.
Absolutely.
Yep.
And,
Yeah, I think you have to look at the specific political environment at the time, 10 years ago when 794 issued. First of all, the dispute between Apple and Samsung was, the patent trial of the century, according to the New York Times. This was there were skits on Conan O'Brien about the case. So lots of attention focused on it. And that's on one hand. On the other hand, this was maybe the kind of nadir of panic over SEPs. The Obama administration in particular was extremely concerned about possible anti-competitive effects related to SEPs. And that's the environment in which this USTR rejection happened. I know what the letter says in terms of the record not being developed. I think that's a little bit hogwash.
Well,
I mean,
they do reference
there's 30 pages in the commission
That's
opinion.
true. And to your point,
discussing-
they
yeah.
do reference the policy statement that was issued by
Yeah.
the Obama administration in that letter. So it's very
Indeed.
much influenced by
Yeah.
what the policy of that administration was at that time. Absolutely.
Sure. And unlike the ITC, the USTR is it's a political actor. It's a much more politically aware and responsible branch than the ITC is, which is an independent agency. So I think there are some key differences. I think if you look back at the time since, there really are two outcomes when a patent owner files an ITC complaint alleging standard essential patents or patents that are possibly standard essential patents.
Disclosed to the SSA.
Sure. There is either a settlement or the ITC finds no violation based on non-infringement. There has not been any instance in which the ITC has refused to issue remedial orders based on some sort of FRAND commitment that wasn't honored.
That's right. I think just dovetailing on that, where the political pendulum has swung, the Trump administration came in and went the other direction, saying that, well, what Obama had in place was very implementer friendly, so it swung back the other direction. The current administration repealed that policy statement and didn't issue one. So now it's kind of an uncertainty, but as we discussed in preparing for this, that uncertainty is, as the market has brought out, is somewhat in favor of the complainants, because they're bringing more cases and they're finding positive results in terms of settlement if it in fact is infringing.
I think that's true. I think nobody knows specifically how the Biden administration will handle this.
Fair.
That being said, their competition authorities, their priorities are elsewhere. They're focused on really the kind of vertically integrated giant tech company, the FANG companies. And so, maybe in some ways, if Amazon, who's the subject of a recent ITC complaint, if they're hit with an exclusion order, I doubt very much there's going to be a lot of sympathy in the Biden administration for them.
And why is that?
I think if you look at the priorities of, there's been a kind of a triumvirate of people put in positions of power with respect to competition policy in the Biden administration, one of whom, Tim Wu, has already left. Lena Khan would be the other. Jonathan Cantor at DOJ, Antitrust Division, would be the other. They have a little bit of a different theory of anti-competitive harms. They're worried about the accumulation of market power in single entities that extends beyond what used to be thought of as a single product market or even a single geographic market. They're worried about the conglomeration of power now. And so I think the framework that they're going to use to analyze competitive issues is not what we're used to seeing, where you define the relevant product and geographic markets, and they're sort of narrowly focused in the classic Chicago school style. And you conduct a SNP analysis and that sort of thing. That's just not the kind of work that they're doing these days. the veteran staff of the agencies is still doing that. But that's not the political actors' area of focus.
Interesting. And I guess I hadn't really paid attention to that simply because I just assumed, Evan, you were just saying, the Obama administration was one way, the Trump administration was another way. In a lot of respects, I think the Biden administration kind of snapped back to where the Obama administration was and kind of reflexively away from anything that Trump did. And with Amazon in particular, and this is a little bit of a tangent, but I'll say it when we move past it, is there was a time when the Trump administration looked like they were ready to go after Amazon to deal with these counterfeit issues. And I had heard through the grapevine that somebody warned the Trump administration, hey, this can't look like it's an anti-Amazon event. You're going hard at Amazon. And yeah, they're maybe a bad actor on the counterfeit, or it could be a better actor on the counterfeits. But it was almost too aggressively going after Amazon to the exclusion of any other platform. So I guess policy is a little bit more nuanced than just all that. But so you all just sat through and heard the last panel on global landscape and global strategies and so forth, and did not have any view on that panel specifically because I wanted to have an ITC specific panel. So I don't think I think Judge Rader's right. You bring district court litigation in this area in the U.S. for discovery, and then you go to the ITC to be serious as a serious component of the global strategy, right? So can each of you give me a sense, and we'll start with you, Josh. Evan, ask you the same question. Judge, I'd like your perspective from somebody who is decider-in-chief on these issues. Where do you see and how do you see the ITC fitting in this global dance that we would just, and for those who are watching this on tape, if you didn't see the previous panel, we had Germany represented, Brazil represented, Colombia represented, and then Judge Rader kind of represented the U.S. view, and among others, the arbitration view as well. How does that fit into that puzzle, the ITC?
So, I think the ITC is a necessary part of any large-scale enforcement strategy. First of all, the United States is the most important economic market in the world. I don't think that's going to change anytime soon. And the ITC is the only forum in the U.S. in which you can get injunctive relief. So as a creator of leverage, why wouldn't you file suit there?
Mm-hmm. Now, what I will say is there will be people that when you say that, they'll say, that's not true. You can still get an injunction in the United States. I think what you mean is it's the only reliable source of an injunction.
You
right?
have a reasonable expectation that if you prevail on proving infringement and surviving validity challenges, that the relief will be injunctive.
Right, and that's not true in district court.
No, not by a long shot.
And it's because eBay doesn't apply.
Correct.
Yeah. Evan, your thoughts. Where do you see the ITC fitting into this puzzle piece?
Yeah, and I think I said on a panel here at a different panel, Litigation Masters are live, that the ITC, if you can get there, because there are procedural hurdles such as domestic industry, if you can get there and you can avail yourself of that forum, you want it part of your global strategy. Most of these strategies are going global now, right? You have Colombia, you have Brazil, you have the UK. The United States market is the biggest market, so if that's part of your strategy, the ITC needs to be a component of that. Obviously, if you can clear those hurdles of domestic industry. And to Josh's point on the injunctive relief, it's also beneficial. It's enforced by customs, right? So you have an enforcement branch that's going to do that work for you. So there is a reasonable expectation that you will get that injunctive relief and that it will be enforced.
Mm-hmm. Okay, Judge, do you have any thoughts on that particular point?
Well, I don't necessarily have a lot to say about that because the litigators and the companies will have their own strategy in that. But I really believe that, and particularly sitting here and hearing about people talking about these patents that might be SEP or might not be, whatever it is, but it seems since eBay that they've put a tremendous pressure on the people to do the holdout. That is the Apples of the world and their smaller prodigy. They have no disincentive And the ITC, to be honest, not just to brag them up, and that seemed to be the last place where you can really punish somebody for holding out and for not negotiating good faith, which is something all the SSOs seem to have taken in. Without injunctive relief and the way some courts have held and the way Apple sees the world, there is absolutely no reason for you to ever take a license until they've tackled you from behind and the Supreme Court has shut you out and everyone else. So I think the ITC's value for a litigator in that has moved way up on a scale, because if you are representing a patent owner in that, the only way you can really get their attention is at the ITC by cutting them off from the U.S. market, because otherwise there's no penalty for just saying F you, and I'm going to keep using your patents until you can hunt me down, and then I'll pay you what I should have paid you 10 years ago.
Sure. Right? I think that's absolutely right. I think we've been talking about the threat of injunction. There's another factor that I think makes the ITC helpful, which is its kind of information creation function. What do I mean by that? When do cases settle? They settle once the parties have more understanding of where they're situated with respect to each other. How does that happen? It happens through courts issuing preliminary rulings, claim construction rulings, summary judgment rulings. At the ITC, that happens very quickly, and it culminates in someone who's very knowledgeable about these issues, like Judge Essex, issuing an initial determination. That happens within a year, typically, after a new complaint is filed. There's trial in 7 to 8 months. The initial determination comes out 3 months later. By that point in time, the parties should have lots of information about their chances of success. I think that's one of the reasons that you see the results over the last 10 years. Either you have a finding of non-infringement and no violation, or a settlement.
Evan, any additional thoughts before we move on?
I was going to hit that speed point, so
Sorry.
I know you nailed it, but that's right. I mean, it's the combination of injunctive relief and the time to trial. Right, time to trial is always an indicator of settlement, and there's no place faster than the ITC, and that's why people keep coming back. Like I said, that's where the serious cases go.
Yeah, the gift that keeps on giving. So I guess my next question is, like, from a timing perspective, when do you advise launching? And I'm assuming, okay, I'm making the assumption that if you really are serious as an SEP player, as an owner, patent owner, you're going to have some resources. So we're not talking about the the jumping rope or something like that, where it's
this isn't your small inventor.
It's not a small inventor. And you tell them, okay, well, what you need to do is you need to file here, 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 here simultaneously. And they look at you and you're like, okay, well, how much is that going to cost? Oh, probably 25, 30 million, like in the first month or two, And it's probably not quite that, but it's 25 or 30 million probably in the first 6 to 12 months for sure. And you create leverage and so forth. So we're talking about a certain scale. Okay, and I want to come back to the cost in a minute, what you tell people to budget. But first, where do you tell them to go first? Where do they slot in? Or do they do this simultaneously? Do you file in Germany and the ITC and Brazil or do you start with the ITC? Do you start with Germany? Do you wait till how's the chess pieces moving on the board?
I think that's different for every case. Honestly, you're looking at the leverage points that you can create, and sometimes you want them staggered. And so you would purposely stagger the filings, and sometimes you would file them all simultaneously. Likely the ITC will be the driver because it's going to be the fastest. And so maybe you try something Colombia and Europe first. You're not getting the traction you want, then you go to the ITC. Some people would rather have the blitz approach and do everything all at one time. I don't think there's any, in terms of that question, I don't think there's a one-size-fits-all type strategy for that.
Okay.
So I agree with that. I would say strategically there is a lot of value in litigating on multiple fronts. you're sort of putting the other side on their heels, especially as a complainant. I think the ITC should be, if you're going to do it, you're going to want that to be one of the first places you file, because we're in the United States. There is a risk of post-grant review. So it makes sense to kind of get out in front of that as much as possible. The ITC is often fast enough to beat post-grant challenges to final decision, but you do have to move quickly.
Okay.
Yeah, let me throw something
Yeah,
in
go
on
ahead.
that. And I just, not just to brag up the ITC, but
We can all do that.
it is the one form that has a rate, if you file there, more than half the time you will go through the complete hearing and that. And district court, it's about 3% go actually to trial and through trial process. So if you want to get another party's attention and, grab their head and say, you're going to go into the mud with me, the ITC is the place to actually do it, because the chances are more than half you are going to have the trial, you are going to have the appeal in that. And I think that sometimes I think Winston Churchill said being shot at clarifies the mind considerably, and I think the ITC is the equivalent of being shot at in these situations, because it's more than 3%. So I would think, and you confirm it for me, litigators, and that, but I would think that that would certainly be another factor to consider, because that's going to send a chill down the spine of someone who really knows what it is.
Absolutely. I mean, and I think the IPR point can't be underscored enough. The institution rates and the invalidity rates at the PTAB are climbing. And to file in a form where you can get out in front of that and get to the decision points of claim construction, initial determination from the judge, all the way through hearing before anything happens at the PTAB, before you get any final written decision, that's the driver.
Let me add on to that, because the ITC, we're kind of an arrogant bunch, more or less. And he just talked about a final decision of the PTAB and that. Well, we don't think that is a final decision. Normally, they will take a long time after we're done in that. Since we don't believe the final decision from the PTAB is what? It's when the Court of Appeals for the Federal Circuit says, yay, that was correct, or no, that wasn't. Yep. So, you go to the PTAB, you get them to say the patent is entirely invalid now. You come to the ITC, we've already done your hearing, we've already done your ID. We don't give a damn what that says. It's still a valid patent, we're still giving you an exclusion order.
And that's order is still going to be in effect.
Probably
while that
another year or so.
appeal goes.
So again,
That's right.
that's another way that there's some pressure for parties settle. And
And that's not what happens in district court, is it?
no, the
No.
district court is binding, but the PTAB, we don't give a
Oh,
damn.
but they also
No.
they stay the case while the PTAB makes its decision.
Right,
So
so
you're
the-
sitting behind. Talk about time to trial. You're sitting behind 2 years when you file in district court a lot of times.
Yeah.
Well, yeah, I mean, the district court judge is going to look for any reason to get rid of the case if they can.
Ronnie tells me
there's
he
a-
doesn't do that. Sit down.
Sure thing. There's a criminal docket that you're competing with. It's hard to get the judge's attention for your little patent case. Whereas the ITC, you don't have that problem. It's all they do.
I mean, again, look at the clock. You file right, your case, Northern District of California, if you're crazy enough to file there. But let's say you file there, and then they put it in PTABs. Now you're waiting 2 years. Somehow you survive that with maybe one claim left. Hopefully, you got a couple claims left in there. Then you go back to California, and you're looking at 4 years, 5 years to trial. You're at an exclusion order for half a decade at that point in time when you're at the ITC.
Yeah. So there's one other reason that I think it makes sense to be aggressive about filing at the ITC, especially in the SEP context. This is some recent case guidance, the 1240 investigation
1240,
again. In that case, the respondents raised lack of FRAN negotiations as a defense. One aspect of the final decision was that the complainant had filed its ITC complaint so quickly that it hadn't allowed time for negotiations to really develop. So there was a lack of evidence as to whether there were not good faith negotiations on FRAN terms. because the respondents were in the position of having to establish this as an affirmative defense. They had the burden of proof. That ended up being a good thing for the complainant.
It opens up an opportunity for move for summary determination or move to strike that defense because it's underdeveloped.
Yep.
So aggressiveness can pay off.
Interesting. Okay. So, I know this isn't in the relevant to SEPs, but I can't help myself. I want to ask simply because, every time I hear you guys talk about the ITC, it just sounds like everybody ought to want to go there in the U.S. And I know not everybody can go there in the U.S., but are there strategies that could make it more likely that people could go there? And obviously, you're never going to get the independent inventor who's going to do the SEP. It's just for a variety of reasons. Even if they could qualify, they don't have the resources.
We had stringed instruments. We had an independent inventor that came twice, and we said
No,
he
but they
didn't
weren't
have enough domestic industry
They
to throw
weren't.
it back
They
out.
weren't SEP holder.
No,
Right,
but
yeah,
he said
yeah.
Right. Well,
independent inventor
yeah.
couldn't get there.
But
so.
I mean, so what can, say, like an SME SEP do, if anything, to avail themselves of the ITC? I mean, because we're talking about people who are just in the R&D business. They invent to create, to license. Is that enough of a domestic industry? And the reason I ask this is because there is a belief by some that the smaller the entity at the ITC, even if they really are, and all their employees are doing business in the U.S., there's going to be a reluctance to find that they have sufficient business being done in the U.S. just based on their size. So what say you all?
Yeah, I don't think that's true.
Okay.
There certainly in the last few years, there have been a number of commission decisions that dealt with SMEs who did have operations based in the U.S. on the smaller scale. But the commission's case law requires that they look at the investments in context that takes into account the size of the business, and so they're not comparing a smaller company to Apple or to Honda or some other giant multinational company. They're evaluating smaller mid-sized companies compared to other smaller mid-sized companies. There's also been a number of decisions where, because everything was happening in the U.S., R&D, manufacturing, sales, it sort of didn't matter whether you compared that to something else. It was sort of almost per se significant and satisfied the domestic industry requirement.
Okay, so and you agree with that, Evan?
Yeah, no, I definitely agree with that. I don't think you need to have a certain threshold. I know you don't. The case law, you don't have to have a certain threshold investment. It is relative to your size. It is relative to what you're doing in the market. It is relative to what other products you sell. So if you're a smaller company, you have one product, and that one product is one that practices your patent, you're in pretty good shape, almost regardless of how much you're investing. As long as you're not doing anything here, you're buying a product off the shelf in China and you're bringing it here and you're repackaging it and selling it. That's not going to fly. But that's not what your question was.
No.
And just make sure you kind of threw in there. So there is part of the statute that says if you have a licensing business, if you have an engineering business. That's what I thought you were going back.
So now we've kind of established that part of the SME equation. So in this area, a lot of the SMEs, they don't sell anything other than either the patents. There's one local here. They don't license. They create, they patent, they sell the portfolio, and then they rinse and repeat. And that's sort of I think a unique approach. The other SME approach is very similar to some of the larger entities. They just innovate and license their innovations. Is that enough? And where's the threshold if it is enough sometimes and not enough at other times?
Right. So under the statute, that technically is a way to establish domestic industry, a licensing-based domestic industry. However, that has not been successful in probably 10 years. There's this another word that people throw out there called trolls, right? And so the ITC had to swing back the other direction, saying, well, that's what a troll does, right? They set up, a licensing-based domestic industry. So there was a very big pushback on that sort of industry being a domestic industry. So what has come out of that, what SMEs would do, they do need that initial licensee right? Because then you can step in the shoes of your licensee and use their investments in the United States to establish domestic industry. So that's been a trend in that direction.
One second, I'll get to you in a second. So the distinction I'm hearing you make is between a licensing program and a successful licensing program that has matured into having licensees who then you use their domestic.
That is the safest way of doing it, right? Not the only way.
Okay.
And under the statute, it theoretically can do it. I think that's what Josh is mentioning.
I think the real issue with your hypothetical, Gene, was the ITC has what's called a technical prong of the domestic industry requirement. What that means is there has to be a product that practices the asserted patent in order to satisfy the domestic industry requirement. I think what you had proposed was a company that's doing all the R&D but then sells its portfolio. It's not clear to me that in that example there would be a product that practices the patents that is identified kind of ex ante. Now, theoretically, could you rely on an accused product or a third-party product and say, well, there is commerce that's going on that is exploiting this patented technology. That satisfies the technical prong. We just haven't really seen that fact pattern go to final decision yet. It has been attempted in some cases.
Judge, I know you were not just a judge. Now you're a counselor and you give advice to companies. What advice are you giving them about access to the ITC and how they can try and gain access?
I say the first thing, to be honest with you, the smaller companies that you seem to envision here probably aren't coming to the ITC because although according to the AIPLA, it's really not more expensive to come to the ITC, you have to come up with the money a hell of a lot faster because district court will last 5, 10, maybe 14 years if you've got a slow-moving ship. So we won't get the real small folks coming to the ITC.
No, I wouldn't expect that you would. So what size?
There's a caveat that we still are, and here's why.
Getting litigation financing.
Litigation financing has exploded in the last, I would say, 5, but even the last 2 years.
Yeah.
So if you have strong patents and there is enough targets, right, to go after, then you can get funding, and the smaller entities can come to the ITC under that.
Even without funding, though, I mean, to be fair, there are cases brought by SMEs at the ITC. A few years ago, we represented a company that's market cap was under $10 million. It can be done. You have to make some decisions about how to be efficient. You can't have the all of the above approach doesn't work. It doesn't.
You have to be careful who you're going after, too. If you're going to go after Apple, they're going to make you spend a lot of money.
Well, and they know if you're only a $10 million company that they're going to outlast you. They probably have to get to the end of this quarter. They don't even have to try.
Right.
Yeah. It depends on what your goals are. If you're the $10 million company and you're going after other $10 million companies, then it's a theoretical possibility.
Okay, so let me ask you all this. Based on your experience, and SME is relative, and I haven't defined it yet because I'm always reminded that at the patent office for us patent lawyers, a small entity has 500 or fewer employees. That is not really. I mean, that's I think the IRS definition of small. So what is definition of small are we talking about here in terms of innovators who you would advise should consider, if you are this size and you have an R&D and licensing, and the ITC needs to be on your radar. And if you're below this number, then unless we're going to be really lean, like Josh was just saying, maybe we need to come up with an alternative strategy. So where, for you, is that line? Josh and then Evan, I'd like you to think about that. Yeah. And Judge, if you have thoughts on that too.
Yeah, I think it's almost a question that's answered by considering what the company's threshold for risk is. If it's
is it more revenue based than size based?
I think that's probably true. How much of your budget for this year are you willing to donate to this litigation option? Here's what it's going to cost. Here's the least that we could do this for. is it a viable option or not? I think that's the sort of calculus that needs to be performed up front.
So I like the way you said that you're willing to donate towards this, because I'm a UFC fan, and I've started getting into, just to make it interesting, playing on DraftKings a little bit, and Renee and I, we were watching something on Netflix about the mob and so forth, and if in back in the day, the people would get into gambling problems, they get problems with the mob, and it's like, whoa, don't bet if you don't have the money.
Right.
Right.
I mean, this is money that you have to plan to lose. So I guess it matters. Well, how big should somebody be, Evan, do you think, before they ought to be having that, I'm willing to roll that dice knowing I could just walk away losing everything?
Right. It's an interesting question because it's one that I actually get quite often, in the sense that you have the clearly can't afford anything and your patents aren't very strong, and who you're going after are knockoff artists in China, right? Okay, your goal is different. You're not necessarily trying to recoup any money. You're trying to stop them from importing, right? Well, then that's a cost you're going to spend with the dollars you're looking to recoup are increased market share, right? So that is a spend, that's a business strategy, right? Then there is, okay, I have a product. I can't sell it because someone's outselling me. They're huge. I know they have the money. So now you're looking at, I need between $5 and $10 million to take two of these behemoths and go after them. And that's where litigation financing comes in. However, then the market has to be a certain size for financiers to get involved, right? They're not going to go and fund a case for $6 or $7 million when you're hoping to get $6 or $7 million out of the case.
So what multiple are you seeing or hearing that the litigation funders are hoping for at the ITC?
10x.
That's what I thought.
Yeah. So there's a spot, right? There's a big spot in the middle. SMEs sit there. That they're not looking for an exclusion order. They're trying to bring someone to license, but their market just isn't 10x.
So they're looking for VC return.
Right.
Yeah. And it's not unreasonable. I mean, there's a lot at risk.
No, but it's
a lot of money, though.
It's shrinking the type of, because now there's more funders. They're getting more sophisticated, and they're trying to lower their risk. Well, one way of lowering their risk is to increase the benefit on the backside.
So that's what I was going to. I mean, that is a way to lower the risk. But it's also a way to miss a lot of good layups. I mean, is there not yet enough money in the patent funder world to drop 10x to 8x? There's a deal makers forum that's next month. Right, you'll be able to answer that next time.
No, and it's a growing asset class, and I think that's the big question people are grappling with is, okay, how do we're missing a whole portion of the market?
Yeah.
And how can we structure this that to make money less expensive for certain actors?
Right, but then you have to increase the certainty that you're going to hit.
Yeah. Well, the law firms have to do it leaner.
Yeah.
Right. In some instances, right. I mean there has to be a decrease somewhere in cost.
Right. Yeah.
Josh.
It reminds me a little bit of the change in the motion picture financing industry over the last 20 years. The sort of mid-budget movies aren't getting made anymore.
That's true. They're good
and
ones.
They're good. That's all like the Oscar winners historically. Right. So we have blockbusters and indies. And
it's a fascinating evolution of the financing market right now.
Yeah. So Judge, when you were sitting on the ITC for a decade, for those who aren't familiar with your bio, during that time, what size? I mean, how many SMEs did you see? Did you see primarily really large entities? I mean, and what size did you? Was there a size you could identify and say, hey, I'm not really seeing anybody below this size?
Well, that's hard to answer. We saw some very small people. I said my favorite was the fellow made a different way of tuning a guitar, musical instrument, string music was his name. And he was not only small, he was pro se. And he didn't have any records. And they threw him out because he was too small. And then Judge Bullock was the one that had him first time. And he made a bunch of remarks about he didn't keep this record. So the guy did all the things Bullock said to do and came back. And he got Bullock again, and Bullock said, still not enough. And the commission upheld it. So we've had that tiny, the one man in the garage kind of thing. Then the other large corporations that is sitting on a bench, I don't know because they don't have to disclose to tell me how big they are and so forth. But I think two things, some of them, particularly when they rely on licensing, then working and trying to get exclusion orders can be very, very important. And so we see those, and I think one of the reasons they come to the ITC fairly regular, and I know I see people out here working with some of those companies that I had in front of me time and time again. I think part of the answer is if you're relying on licensing and everything important in that, you need the ITC to get your revenues quickly. Because if you sue in district court and the judge is comfortable and says, you know, we'll get you in 5 years, son, don't worry about that, because I don't like these cases anyway. So they know they'll get quick resolution. And so I think we get those folks in that. We've got a number of companies that were entirely dependent on licensing revenue that did not make products. We had some of them that used to make products and don't anymore and now rely on that. So I think those people had a little more sense that they need to get the ITC because they need to get that revenue stream coming one way or the other. I want to tell you one quick story because I know you hate the word troll. But there were a pair of attorneys that I believe left a firm, McDermott, and they bought some patents, and they actually, you know, they actually, and this is, I know because I held the case, but they rented a post office box down in Tyler, Texas, so they could have residents there. And they.
So the term troll may actually apply to this.
Well, there are two attorneys who bought these patents, and then what was really interesting, to establish a domestic industry. I tell you stories in this one. Francis Ford Coppola has a winery. I don't know if you all know that, and he would make box wine, and he named it for his daughter. And I can tell you with certainty he did not like his daughter very much because Sophie, the box wine, was wine that was served in cans with a straw on the top of it like a juice box. And it was a sparkling wine. So, you know, Sophie was not a favorite daughter to do that. But they got a license.
She's just angry about Godfather 3.
Yeah.
Yeah, that may have been it. That may have been it. But they took a license from that company, and they basically gave them the license to, if they would sign a little affidavit that says how important putting boxes around the cans are. And 4 others. And they tried to come to ITC and said, look, we have a domestic industry because we had this one lady who made a lip balm, and it had a cardboard container on it, and Sophie had a cardboard. There were 2 other products. And that was domestic industry. They were trying to make it on their own. So they were terribly small, and they basically would sue companies, and they'd settle for $500 for a license. I mean, but if you sue 40 people and you get $500 for, you had a good day's work. And they came in front of me, and I found they didn't have domestic industry and kicked them out, and that was upheld all the way. So we have very small things, and we've had that kind of person come in, but mostly fairly large companies, and I would say quite a bit of them come to the ITC for the speed and the assurance. And I saw particularly a lot of companies that did not make their own products. I think we were more important to them because we were the licensing, and the ITC was their revenue stream. So I think there are probably a number of factors that go into it, but I think that's one that really drives the smaller or medium-sized company that you're talking about.
Okay. So I want to give you guys sort of like the 6 minute. We had 6 minutes left or thereabouts, just to give you a reference point. So the question that I started with, that I said we get back to, we kind of danced around a little bit. You've thrown out some numbers here, some numbers there. What is a bare bones ITC approach? What is the Cadillac? So what's the Yugo? What's the Cadillac and what's the Maserati? I mean, how much are people budgeting for these things? When I just enough because I need some help and I got no other hope. You know, the Yugo, it's a car. It gets me from point A to point B.
Not usually.
Yeah, not anymore, right? But Josh, what and Evan too. I mean, what should people be budgeting? Because it's still a pretty big number, right?
It can be. It depends on a lot of different factors. The complexity of the technology is a big one. If we're talking about litigating 3 design patents, that's going to require a different budget from, $7 patents dealing with complex wireless standards or semiconductors.
Sure.
Sure. It depends who is on the other side, because we need to know how litigious they're going to be, how much resistance they're going to put. If in our 3 design patent case, we're suing 5 Chinese companies who are probably going to default, I could put together a budget for that case that's under $1 million probably. For the 7 wireless patent case against Apple.
Before we go there, go to like the 3 design patent case against Apple. I mean, just so that we have sort of, because that would be both sides of the spectrum, right?
Well, then that's what Apple, Samsung involved design patent case. You're looking at, you're in double digits $1 million.
Yeah. So, that case is going to be heavily litigated.
So that's like 10 or 20x, right?
No.
No?
I mean, it's still simple technology. It still doesn't require a ton of discovery. An aggressive budget would be $2.5 million for that case, I think.
Really?
Let me throw another thing in there, because the ITC has another advantage over district court in that they can sue, my friends here can sue as many respondents as they feel they can handle. So if you want to sue, and I had this in front of me, at least 20 different respondents, the budget's going to be a lot different, because that's 20 people who can get discovery from you. And in my particular case, the case dropped out because the complainant told me there were too many people demanding discovery. I said, well, you sued them. Since you sued them, they get discovery. I'm sorry. And they had to back off of that. So, and that in district court, theoretically, you could only sue one person at a time, one entity at a time.
And you can't do that at the ITC?
You can sue as many as you think you can handle.
Right now, but you could go, to make sure that you are capable of keeping up with the other side, you could go lower, right, to start with.
You can file against one entity?
Yeah.
Sure.
Oh, absolutely. But the fact,
one of the sacrifices one of the advantages of the ITC, though.
Right.
There's obviously there's a tipping point, right? There's efficiencies gained by naming more than one respondent at a time. You quickly can go the other direction too far if you get in the 50 range, which we've seen.
Right.
We've seen close to 100,
yeah.
right? And so now you have to really staff up just to keep track of what's going on, the proofs you have from the discovery from this entity, and because essentially it's 100 different cases all at one time.
Okay, so wireless, say,
I know, most of them defaulted. I get it.
Telecommunication standard, you have, let's just say 20, like Ted was saying, 20. So it's not like NASA sending something out to try and orbit a black hole, kind of sophisticated, but it's 5G.
Right. 5G is going to involve source code. You're involving standards. You have how many targets? 5 patents, 20 targets.
20 targets. How much?
You're definitely you're over $10 million.
Yeah. Oh yeah, easily.
Easily. Because we all know who those targets are going to be. It's probably going to be more than that. And this is just the ITC side of it.
Right.
You're going to have parallel. You're probably going to want to have a global, means you're in that area, and you have appeals. So the ITC component.
But that's why you use the ITC, and you use Germany, and you use Brazil, and you use these other places, Colombia and elsewhere, to overwhelm and try and get it to the point where this settles rather than go.
There's 2 reasons. Well, there's 2 major reasons. The overwhelming point, right? There's also you could get a bad beat in any one of those jurisdictions, right? And so you need to have other bites, other ways of getting to your end result, which is essentially you're trying to get them to settle or you're trying to get them to take a license. So that insulates you from that. There's the other side of it, obviously, is the pressure that you're inflicting. And so you have multiple decision points, which brings about getting people to the table and getting to resolution. You also have multiple outs, or I guess multiple ways of winning if one turns out to be an out.
Okay. All right. So I would like to give, in the final minute or 2 that we have, each of you an opportunity to wrap up with your final thought. We'll give Judge Essex the honor of going last, final word here on the panel. Josh, what do you hope people remember from this conversation?
I think one of the themes is that the ITC is a great forum for increasing leverage. It is available for a range of different kinds of companies, including SMEs. You have to make some trade-offs in filing suit and in how you structure the lawsuit, but it's doable. And I think you have to look at what has happened, what's the track record. In the last month, we've had new complaints from Nokia, we've had new complaints from InterDigital. clearly there's a sign the smart money is on the ITC as a forum.
Great. Thanks, Josh. Evan?
Yeah, I think if you value the United States as a market and you can avail yourself to the ITC, it absolutely needs to be part of your litigation strategy. And bring it back to this panel or this conference on SEPs, I think we've, as we've analyzed, and as Josh noted at the very beginning, it's probably one of the premier forums for litigating SEP patents.
Great. Thanks a lot, Evan. And Judge, your final thought.
Well, my final thought is, first, we've beaten back those who said that because it only offers exclusion orders, injunctive relief in that, then it shouldn't apply to any SEPs. We've beaten back the idea that the SEPs will litigate there, because both sides have generally shown that whether or not a patent is standard essential, whether it's not a factor in litigation of the ITC. So it's a form that's available, and it's a form that can get it done quickly. I think in some ways it's the only effective form you have, because, again, a lot of foreign entities and that import really aren't available at certain district courts and that because of jurisdiction that. So I think we've shown we can handle these things. We've shown that it's appropriate even within the so-called SEP setting and that. And I think going forward, it's a very valuable tool for those that want to defend U.S. industry and U.S. patents.
Okay, well, great. Thank you very much for an excellent conversation, guys. I really appreciate it.
Thanks, Gene.
Thanks.